So we are moving to the first substantive presentation, which is our first panel, our conceptual approach to climate rights, the rights-based perspective to EU and national climate policies. And who is going to present the concept of climate rights, which is the basis of our project, is going to be Mr. Plamen Peev, a legal expert from Bulgaria, from the BlueLink Foundation. And I start your presentation, if it's okay.
Good morning, everyone, and welcome. I'm really thrilled to be with you in this beautiful building and environment, and among many environmental lawyers, but also other activists in the field of climate protection, environmental protection. And it has been quite a long journey, even it was only about 2 years of the project, and we wanted to present to you our conceptual journey in a way, and some of our ideas which came along the way. So when once I came across recently this article in the New Yorker, which was titled "The Right to a Stable Climate is the Constitutional Question of the 21st Century," I thought to myself, well, we are on the same page with the New Yorker, and we are more or less going toe to toe with exploring this concept. And however, I saw then the date of the article, which was June 15, 2019. It seems that many people have thought about the climate rights before us, and we knew it hypothetically, but when we started to think about how to approach the issue of climate change and involvement of the society, and how we could put it into the scope and the framework of the rights, we have had some basic idea, and although we didn't live under the illusion that will coin a new concept, but still we wanted to identify what is important for our project, to put some starting point, and to frame our research and our activities so that they will have a conceptual basis. So in 2022, we thought that if we want to reflect the global dynamics of climate change agenda, we need to explore this new phenomenon of climate change and climate rights, and the use of the law to protect the climate system. And of course, this new notion, we wanted to highlight that the climate change is not only scientific or technological issue, but has its legal and more broadly societal dimensions. And since we wanted to go further in the exploration of this concept, we thought that how we will define the climate rights, within what assessment frameworks, how do we want to classify them, so that we understand better when we approach them at the national level. And we started to think that it's important already in 2023 that we need to have a special study on EU level, which will inform also the national activities later. So we decided to have such a special study, which was not meant to be under the project, but it was a very good help for every one of us, so that we established the ground for the further project activities. And then we moved on with our understanding of climate rights, and we said that we want to define them as this variety of existing and nascent categories of rights at the international, EU and national level, with reliance to climate change, and very broadly defined as all substantive and procedural rights related to or affected by climate change. As an operational definition, we had this the purpose that this definition will guide and inform our study of climate rights as vehicles for just and engaging society, in which the climate justice and the protection against the consequences of climate change will be high on the agenda of the governments, businesses, and the society as a whole. So we introduced a few frameworks to assess and understand the climate rights. First, the rights and their relevance to climate change, with some question, as you could see, what does a given legal normal standard actually aim to protect, and how this scope of protection interacts with climate change, or how we define the climate rights. Do we define them as individual or collective rights, or as substantive or procedural rights? Well, the first dichotomy of rights, we wanted to help us to identify the societal effect of the climate-related rights, considering the rights holders, while the second one, substantive or procedural rights, was relevant for the function of the rights to defend values, conditions, interests like life, health, property, food, or as procedural rights to ensure due process and administrative procedures that enable defending substantive rights. And finally, we wanted to look at the climate rights in the framework of climate litigation before international, regional, and national courts. Climate rights most frequently and also mostly are defined as a category of climate rights as climate litigation rights, as a category of climate rights first and foremost, and also climate rights which are emerging from constitutional fundamental rights under the domestic law, but often also relate to international obligations under the Paris Agreement. However, as you also could see from other sources, the climate rights could be defined not only as climate litigation rights within the climate litigation description, but also as academic political debates moved by the academic and political debates, but also part of the legislation already, rights which are defined in the legislation, so that they could reflect the changing social and legal context. In our study, we have used to some extent the classification suggested by the UNEP and Sabin Center of Climate Change Law of Columbia University in their studies of global climate litigation, but we have further defined them and expanded them to the following categories, including fundamental human rights, social rights and just transition, domestic enforcement of climate goals, corporate liability and responsibility, including, for example, unjust enrichment, consumer protection, stakeholder litigation, and so on. The right to proper climate adaptation, and also procedural rights, which are enshrined in the most prominently in the Aarhus Convention of access to environmental information, participation in environmental decision making, and access to justice in the context of climate change. And very specifically, we also looked at the procedural rights in the context of environmental impact assessment and strategic environmental assessment, because this was one of the topics of just environment we are exploring, not only through this project, but also many others. And just shortly, to remind ourselves why the fundamental human rights could be defined also as climate rights. you could read already in 2015 in a report of the UN Office of the High Commissioner for Human Rights that the human rights mostly affected by climate change include the right to life, the right to self-determination, to development, the right to food, the right to water and sanitation, to health, and so on. And also concerning the real cases, court cases before, for example, the European Court of Human Rights, usually Article 2, right to life, Article 8, right to respect for private and family life of the European Convention of Human Rights, but also the Article 1 of the additional protocol to the convention, right to property, have been involved in the climate injustice or justice for children, the relevance to children's rights. So that was important also to see that, for example, a right to protest in climate strikes, for example, it's one of the areas where we could expand together with many others. And I just wanted to give you a few examples. For example, for climate rights already defined in the legislation, like in Spain. The Spanish climate change law already includes specific legal provisions which link the climate change with the protection of other relevant rights. For example, Article 23, its relevance of the climate change to public health, or 22 to food security and diet, just transition and employment rights, Article 27 to 29, and so on. So as we see this area, this overarching concept of climate rights could be defined through the litigation, going to court based on the more traditional environmental or human rights. But we see also developments, legislative developments, which show us that the countries already are adopting specific climate change litigation legislation, which of course will improve or enlarge the possibility to go to court. And finally, just wanted to point out some trends in the climate rights cases, which include, for example, the post-disaster cases, ecocide and criminal law, and synergy between environmental and climate litigation. For example, when the climate litigation strategies are increasingly applied to environmental cases, such as plastic pollution or air pollution. So in the end, it's really about how we define the climate rights, how we reach out to different groups which defend them, because we have found out that, for example, in Bulgaria, the people and the activists and lawyers working on human rights cases wouldn't consider themselves working on climate cases, but even more, people working on air pollution cases, they wouldn't consider themselves lawyers working on climate cases. And we try to break down some barriers or silos between different areas of law, and not only law, but also civil society organizations and interests behind. So in the end, it's a really exciting journey. And coming back to the article in the New Yorker, we sooner or later hope that in our constitutions and laws, there will be a special right to stable and predictable, safe climate, and that will be ultimate and maybe the best and clear example of climate right. So I was really happy and honored to work on this project, and we want to say just that our publications, our work will be just good, I hope, incentive for all of you and us to continue working on these cases in this field, developing the legislation, the litigation, and also academic debates around these issues. Thank you very much.